Thank you. Please be seated. Good afternoon. We have three cases, or four cases, that will be submitted. Those cases are DuTrac Community Credit Union versus Douglas and Sheila Hefel and Westgate Communities, LLC. The other three cases are all State of Iowa versus Iowa District Court for Scott County. Those last three cases are now then submitted to the court without an oral argument, and we'll hear the arguments now in DuTrac Community Credit Union. Mr. Lalor, you're going to proceed first, is that correct? All right, you may come forward.
May it please the court, counsel. My name is Brian Lalor, and I'm here representing the appellant and cross-appellee Douglas Hefel and cross-appellee Sheila Hefel. I'll be brief, reserving a minimum of 10 minutes for Mr. Kane on behalf of the appellant Westgate. I'd like to begin with the jurisdiction issue regarding Sheila Hefel. She is, as I stated, a cross-appellee only in this matter. DuTrac argues that the court lacks jurisdiction over Mrs. Hefel, but nothing in the August 8th order was adverse to her interests. DuTrac's own briefing agrees that a party cannot appeal from a finding in their favor, and DuTrac's cross appeal regarding the quashed executions in favor of Sheila made her a party to the appeal. Accordingly, nothing requires her to file a notice of appeal to defend the cross appeal against her interest in that matter. Regarding the DuTrac's failure to preserve error on the unlimited continuing guarantee and commercial loan agreement, DuTrac argues that the guarantee and loan agreement preclude the Hefel's defenses. It's well established that an issue must be raised and decided below to be argued on appeal. Further, the Johnson Equipment case cited by DuTrac does not support their claims, as it still requires a party to have previously raised the issue at the lower court. Accordingly, DuTrac has failed to cite anything in the record where these issues were urged below, and therefore the preservation and the arguments regarding the unlimited continuing guarantee and commercial loan agreement are not properly before this court. Finally, the motion to quash on the multiple garnishments. Iowa's a long and robust tradition of debtor protection, which includes chapters 626 on executions, 627 regarding exemptions, and 642 detailing garnishment, which are referred back to in 626 as being on execution. DuTrac argues that limiting collection to one source of recovery at a time per defendant is contrary to the purpose of the code. However, the purpose of 626, 627, and 642 are not to enable collection, but rather to limit it for the protection of debtors. Protection provided by 626.3 allows for orderly collection and provides debtors an opportunity to preserve all rights and objections, rights to objections and exemptions. Read together, the district court found that the code does not contemplate numerous simultaneous executions. The code provides for specific notices, and now this is more related to the garnishments. The code provides for specific notices and timelines which are triggered by the date each garnishment was served. Multiple garnishments at a time would create, additional deadlines by which each debtor would have to object to each separate garnishment or otherwise preserve any of their exemptions under that garnishment. Accordingly, allowing multiple executions or garnishments within a single execution creates a system where debtors, even if they have the financial ability to afford counsel, could easily be overwhelmed by the volume of pleading that could be put forth by a creditor who typically has much greater resources in order to pursue that.
I mean, but as a practical matter, if you're chasing money around and you have somebody that owes you a lot of money, it strikes me that if you can only have one garnishment at a time, once you do the first one, the debtor's kind of on notice, and then the assets will start moving around. It doesn't seem like a very practical regime to me.
And I believe Your Honor, I believe the code then provides for a judgment debtor's exam following any garnishment, And in my experience, both collecting and defending collection actions, that's the point of the judgment debtor's exam, is to then get a debtor on record as to where those assets are and pursue your next subsequent execution. Failing to do that would, again, creates a system where there are protections that are provided by 627 with the exemptions, but a debtor would have, potentially so many different garnishments or executions going on at once. It would become extremely difficult, I would think, for them to be able to preserve those. And that, again, going back to the nature of Iowa's debtor laws, is to protect the debtor. We have the unlimited homestead exemption, and numerous laws that far exceed many of the other states around us, and the federal exemptions. So I think that's...
I think you've addressed some practical concerns, but is there some specific statutory language that directs us in that way?
And the case law and the code are not incredibly robust in that, but it says one execution, and I believe in practice that is generally has been, and the case law that's cited in the briefing talks about one debtor who had multiple executions against a farm, a mule, and equipment, and it was found that they had waived their right by not objecting to the multiple executions, but that, had that been had they made that objection, I believe the case law supports that they would have been only entitled to one execution at a time. Mr. Kingo, thank you.
Right. Mr. Lalor, thank you very much. Mr. Kane.
Thank you, Your Honor. May it please the court, counsel. My name is Brian Kane. I'm with Kane, Norby, and Reddick in Dubuque. I represent Westgate Communities, LLC. The primary issue that I'm here to discuss with you today is whether the district court in Dubuque County erred in granting DuTrac's application for a charging order against Douglas Hefel's membership interest in Westgate Communities. In simpler terms, our argument will bear on whether, or is it appropriate that DuTrac have multiple chances to collect against this particular asset and other business assets. The facts in this case are fairly complex, but to distill them down, Star Properties developed some real estate in Jackson and Dubuque County. Mr. and Mrs. Hefel were the 50-50 owners of that. They started that development in 2008. They borrowed money from DuTrac, gave a mortgage and a personal guarantee. Unfortunately, 2008 happened. They ultimately defaulted. DuTrac foreclosed and got a judgment for foreclosure and a personal judgment against the Hefels for a significant amount. The Hefels filed bankruptcy in the United States Bankruptcy Court for the Northern District of Iowa, Cedar Rapids Division. DuTrac filed a proof of claim in that bankruptcy, as did Westgate, I might add. And during the bankruptcy proceedings, the bankruptcy trustee requested that the court accept a compromise related to Douglas Hefel's interest in Westgate and other businesses. A motion approving the compromise was issued by Judge Kilberg after a vigorous hearing by all interested parties. During the bankruptcy proceedings and at the conclusion thereof, the Hefels were discharged from their debt, but later that discharge was revoked. As far as this case is concerned, thereafter, DuTrac sought to enforce its judgment. Mr. Lalor has discussed.
I think I understand the basic factual scenario. Let me kind of crystallize how I see this, and then tell me why I'm wrong. You had this compromise that's approved by the bankruptcy judge, and it decides that of this interest, basically the LLC interest will be retained by by Mr. Hefel outside the bankruptcy as his personal property, and then a certain sum of money in return will go into the estate. So you have the estate pool and Mr. Heffer's personal pool. Then subsequently, there's a revocation of discharge. And as I understand the revocation of discharge, the legal effect is that the creditor can now go after Mr. Heffel's personal pool. So what's wrong with that?
What's
Isn't
wrong
that
with that?
all that the compromise decided was, you
No,
know,
I-
which part of the asset would go? I'm sorry, let me just finish stating it, and then I do want to hear from you. Which part of the, what would go to Mr. Hefel personally, and what would go into the bankruptcy estate?
The compromise proposed by the trustee and is ordered by Judge Kilberg was to accept a certain payment, $125,000, for Westgate to waive its $145,000 claim, and for DuTrac to participate in its share of the $125,000. That was approved. So in this case, the common theme is that DuTrac has acknowledged that they were the primary beneficiary of that compromise, that they got their share of the money, that Westgate withdrew its proof of claim, and ultimately DuTrac voluntarily dismissed its appeal over the compromise order. Now, it's our view that there was a full and complete bankruptcy, and that bankruptcy remains of record. The only thing that happened was at the very end of the continuum of the bankruptcy, the revocation originally granted was revoked, but all of the other orders, all of the other proceedings remain of record in the bankruptcy. The revocation of the discharge only said that the Hefels would not be discharged from all of their debt. But during those proceedings, and Iowa law is pretty clear on this, that it will respect the laws of the bankruptcy court. We've cited the case in our Grinnell Overland, I believe, was the case we cited in our brief, that the Iowa District Court, or this court, will respect orders, judgments, and decrees of bankruptcy courts in the state. So even though the revocation of the discharge occurred, the compromise was not supplanted. So DuTrac, by its voluntary, knowing participation, has either, and accepting the money and not returning it, has either waived their right to further proceedings against the same assets, or has elected that remedy, or has received an accord on the satisfaction of its right to pursue Westgate. The consideration was the money they received, their voluntary participation and action, and the fact that they haven't returned anything. And Mr. Hefel, by virtue of Judge Kilberg's order, which has not been rescinded, gets to have exempt from the bankruptcy vis-a-vis DuTrac, Westgate, and the other listed assets. Now, the fact that the discharge was revoked means that if, to the extent there's any other creditors, they can pursue his other property, but we believe DuTrac is barred from that by virtue of these facts. Is that responsive?
Well, I'm going to, I guess I just take exception a little bit to the characterization of that. There was a compromise by the trustee in bankruptcy. It didn't really involve DuTrac, from my understanding. They resisted it. They did not go along with it. They offered a separate proposal at one time and then withdrew that. With the revocation of the bankruptcy, obviously you can't go back and the bankruptcy court's order regarding this compromise settlement, but to me it really means that you start back from square one. We're not going to unravel it, but I have all the same rights and abilities to try to collect on any asset that I can from Mr. Hefel, And why is that not right? You know, you can go through the various aspects of accord and satisfaction, which again, I just don't think you meet those. That's just me. I just don't think you meet those various accord and satisfaction, waiver, and election of remedies, because it just doesn't seem to me to fit neatly into this when it's ultimately the discharge is thrown out because of the fraud of your clients.
I believe that the Grinnell Overland case is precedent that this court should consider giving effect to Judge Kilberg's order. That
Well,
case,
we're giving full effect to it, but I assume also when DuTrac has now started the collection action on this, that whatever claim in bankruptcy that they actually did receive has been used as an offset by you, I assume. I mean, they aren't trying to collect double from the bankruptcy, their claim in bankruptcy, and then now collecting it separately, are they?
well, I think the answer is they had a whole panoply of remedies available to them, that they ultimately dismissed their appeal. That was a voluntary action by them. They got their money, they didn't return it, and Judge Kilberg's order is an order, a judgment, a final order, a decree, however you want to characterize it, and that should be given effect by the Iowa court. And if it's given effect by the Iowa court, then we should defer to that. And since that hasn't been overturned, and since DuTrac dismissed their appeal of that, that's what we're left with is in terms of their position as to this. So it would be our view that, in response to your question, to not give effect to Judge Kilberg's order gives a second bite at the apple, which isn't warranted in this case, for all the reasons we cite in our brief. Thank you.
Thank you as well, Mr. Kane. Mr. Arling.
May it please the court, counsel. My name is Peter Arling. I'm with the firm of O'Connor and Thomas, PC in Dubuque, and it is my privilege to be here this morning on behalf of DuTrac Community Credit Union and its member owners. Before we get started, I just want to point out that I have been involved with this dispute since 2009 or 2010, and at every step of the way, I don't know if you're familiar with that whack-a-mole game that children play, but this feels a lot like that to me. Every time we have an argument or every time we have an action, I have these entities that keep popping up, various Hefel-owned or Hefel-affiliated entities. And frankly, we're asking this court to help us whack the mole again, as we have at every step. Before I get into my argument, I do want to point out one inconsistency that Mr. Kane brought up. He indicated that DuTrac had a judgment against Mr. and Mrs. Hefel at the time of their bankruptcy. In fact, DuTrac did not have a judgment. And that defeats all of these defenses that are being raised by Mr. Kane. DuTrac's first judgment against Douglas and Sheila Hefel came after the discharge was revoked. So for a little perspective, there was the foreclosure proceedings. On October 8, 2010 was the first day that we had a judgment. I apologize, I don't remember if it was the Jackson County judgment or the Dubuque County judgment. October 8, 2010 is also the day that Mr. and Mrs. Hefel filed bankruptcy. At that hearing, the judge dismissed Mr. and Mrs. Hefel because of the automatic stay, which I'm sure you're familiar with. We never obtained a judgment against Mr. and Mrs. Hefel. We did get a judgment against Star Properties. As indicated, there was an unlimited continuing guarantee that had been signed by the Hefels, and that is where their liability stemmed from in the bankruptcy case. DuTrac went ahead, liquidated the properties, applied those proceeds. A question earlier, did we apply the proceeds from the trustee? Yes, we did. That was applied to the debt later on. But liquidated the properties, then filed a proof of claim in the bankruptcy court. That proof of claim came up to $750,000, give or take, after the properties were sold. At no point during the bankruptcy did they claim they didn't owe the money. So again, through bankruptcy, DuTrac did resist. There were multiple different proposals put out there. The compromise, as has been pointed out, was only between the trustee and the Hefels, and that was approved by Judge Kilberg. You will have a hard time finding anything in that order or anything in the compromise settlement that shows that DuTrac in any manner was a party to or was bound by that compromise. What DuTrac received from the bankruptcy court was its share of the dividend from the bankruptcy estate. There was also some preferential payments that had been made on, I think it was several credit card companies. Those were brought back in, so they got put into the pot. So this pot that the trustee creates in bankruptcy, ultimately of the $125,000 that the Hefels paid to buy their stuff back, plus the $12,000 or $15,000 from the credit card or mortgage companies, all that went in, called $140,000. Most of that money went to pay the trustee and the trustee's attorney's fees. What DuTrac received was nothing more than a dividend in the estate, same as any other unsecured creditor would be entitled to. So going specifically into the arguments brought on the charging order,
I would assume that if we didn't have this subsequent, and it's been a long time since I've done bankruptcy, but if we had no subsequent action, DuTrac would have no claim, you'd be done.
You are absolutely right, Your Honor. Had we not been able to get the discharge revoked, DuTrac was done. And it was because of fraud that was brought to the light of DuTrac that we were entitled to bring the post-discharge revocation proceedings. Within 1 year of discharge or final order, case closes, is your limited window. And we brought it within that year because items came to our attention within that 1 year. Because we were able to bring a discharge revocation proceeding, DuTrac's ability to go back after the Hefels under their continuing limited guarantees began anew. And ultimately, when we obtained that extraordinary remedy of having the discharge thrown out, that is when we filed our state claim for money judgment. And that, Your Honor, is the first time DuTrac had a judgment against the Hefels. It was November and December of 2014, if I recall, when we had an order and then a 1.904 motion order reissued as well. So you're absolutely right. Had we not prevailed in the revocation of discharge proceeding, had DuTrac not prevailed, it would have been over. And up until the fraud was brought to DuTrac's attention, frankly, we thought it was over. So again, we go forward, we get our judgment. There's nothing in the compromise that binds DuTrac. There's nothing in the bankruptcy code, nothing in the bankruptcy court that says we can't go after those assets. After we get our judgment, we started pursuing garnishment. Both, excuse me, we pursued garnishment against a number of assets. And there is nothing in, well, I'll get to the garnishment in a minute, but with the charging order specifically, everything that the charging order is based on is per the statute. It's verbatim out of the statute. What we asked for and what Judge Bitter allowed us is what the statute allows. Now, again, they're arguing accord and satisfaction. That doesn't apply for the reasons set forth in our brief. Election of remedies, we had no ability to elect in the bankruptcy court. We had no judgment. How could we have elected a remedy that was not available to us? The waiver doctrine, there was nothing to waive. They're claiming that by dismissing the appeal based on the mootness doctrine, waived any right. I'm sure you're familiar with the mootness doctrine, but at the point where Judge Reed in the federal in the federal court, when we appealed it, it went to the bankruptcy appellate panel, and then through an election made, frankly, I don't remember if it was us or by the Hefels, it was brought back to the district court. We were trying to get a stay. Judge Kilberg said no stay, and then Judge Reed said no stay. Under the mootness doctrine, by the time we could get a result, the deal was already done. There's nothing we can do at that point. So how is the mootness doctrine a waiver? How is, instead of waiting another month and having them throw us out based on mootness, how is that a waiver? It's not. The last couple of things on the charging order, they claim the operating agreement precludes it. It doesn't, for the reasons set forward in our brief. The operating agreement is dated 2003. As you're probably aware, January 1, 2009, Iowa adopted the revised Uniform Limited Liability Company Act. And that's the first time this idea of transferable interest came into being. Kind of a neat approach that the legislature has taken and part of the Iowa Business Section Council as we prepared that. Transferable interests are just that kind of monetary right of your LLC interests. The operating agreement doesn't speak at all to transferable interest. It talks about units, kind of like a share of stock. It's an all or nothing type thing, you know, whether it's one of the units or all 500 or however many units Mr. Hefel has. But even if, and I pose it doesn't, but even if it somehow would preclude us from doing that, the operating agreement itself has a carve-out that says, if you're going to sell these units, and if you're going to consider this charging order a transfer or a sale or some sort of an assignment, if you're going to do that, then you first have to let the operating, or the entity or the other owners buy it. So it has its own way out. Interestingly enough, that's the same language that's contained at section 489-503, I think sub 4 of the statute. At any time, the member who has been hit with a charging order can get it released by paying the debt. And if that person doesn't, and if the other owner, and remember Westgate's owned 50% by Mr. Douglas Hefel, 50% by his brother, Mr. Terrence Hefel. If Mr. Terrence Hefel doesn't want DuTrac to have a charging order, pay us off. And it goes away. Or if the entity doesn't want a charging order out there, 489-503 sub 4, pay us off. It goes away. So there are remedies out there. Nothing precludes this charging order. And I would pose to the court that the statute itself, I think it's 489.112 or 114, indicates that, you know, you can have certain, it's the effect of the operating agreement to third parties, not members of the entity. And it specifically carves out for, you can't make changes that would remove the effect of a charging order. Again, the legislature has thought of, you know, if you have a charging order, first off, it's the exclusive remedy against the member's interest, and the legislature has already said, in the statute, you can't wipe out that ability for a creditor to obtain the benefit of that charging order. Frankly, the charging order was issued appropriately and correctly, and we ask that this court affirm the district court's entry of the order on the charging order. Now going to garnishments, and this is something that frankly surprised me when the district court came back and said we had done this incorrectly. We only ever issued one writ. One writ was issued. Now, the directions for service that go along with the writ had multiple items being garnished. Wages, a very valuable TIF agreement with the city of Bellevue that the Hefels had with Star Properties, and then shortly after their bankruptcy assigned to themselves. So we were able to go after that. There are a number of assets. To hit on a question that was raised earlier, what happens after you garnish? People get wise. You have one chance out of the gate to make the biggest impact. It doesn't impact their exemptions. Their exemptions are always there. And it's up to the debtors to come into court and claim their exemptions.
The practical concern that I had is, back in the days when I did collections, the way I would proceed is I would try to gather information, say a credit report or something like that, to find out where the debtor potentially had assets, and then go and try and get at those assets before the debtor kind of knew what I was up to and could move them out of those specific banks and that brokerage account and so forth. If you do a debtor's exam, then the debtor knows that after they've given the information, they go and move it from where they've told you it was at the time of the exam.
Exactly.
That's the practical concern.
Absolutely, that is the practical concern. But even in the statute itself, the practice that we were doing here, we've done on many occasions. I've taken this approach in different states as well. I have the privilege of being licensed in Iowa, Illinois, Wisconsin, and Minnesota, and I do a fair amount of collection in Iowa, Illinois, and Wisconsin. I've taken this approach many times. My partners have taken this approach many times for exactly that reason. Once the cat's out of the bag, it's much harder to find assets. But more importantly, there's nothing that precludes our approach in the statute. And even, I know the judge in this case gave very short description as to why we lost. It almost felt like a splitting of the baby, if you will, to me. All right, we got our charging order, but we're going to have to scale back a little bit on the garnishment. Even the sections cited don't make sense to me in that, yeah, if it's other than a money judgment, you're going to have to specify that single act you have to take. Well, in this case, we have a money judgment. What's the difference between us listing those assets or us asking the sheriff, Mr. or Mrs. Sheriff, please go out and just find assets under a general execution? Because you can do that. You can issue an execution that says, hey, we don't know what they have, but please go find it. Some people call it a sock drawer count. Some people call it different things, where they will literally go to the debtor's house, knock on the door, walk through the house, catalog a bunch of different items, and then you have to bring in 2 commissioners and have them appraise it and determine what it's worth and do all that stuff. What's the difference? And I would pose to you, there's no difference. If I simply save the sheriff the time, identify those assets, and say, hey, on our first shot, we know they have this. Based on 6, 7, 8 years of litigation, we know they have this. Based on all the fraud we uncovered, we know they have these items. It won't shock me if, when we go back to collect next time, some of those items I'm looking for now, strangely enough, disappear. I mean, we've had a lot of time between that garnishment order and now. And again, I would pose to this court, there is nothing in the statute that precludes the garnishment activity that we undertook. While Iowa does have beneficial debtor protection laws, I would pose to you that it's not to just protect the debtor at every turn, it's to have a measured approach to collection. And in the reason, and in having one writ of execution issued, you have that measured approach because it goes through one sheriff's department, which we did. Even the assets that we were garnishing in Jackson County, Iowa, which is just south of Dubuque County, even in that situation, it was through the Dubuque County Sheriff. So again, the rules aren't set up just to protect the debtor, it's to provide a reasoned and kind of a more structured approach to collection.
Your
Yes.
interpretation of that language is you can only have one kind of public official on the case at a given point in time.
Correct.
Not that you can't be pursuing different potential entities that might owe money to the debtor.
Correct. And I see I'm about running out of time. May I respond? Oh, sorry, Chief Justice, may I? Okay, thank you. It's our position, not that you can only have one public official, because you might have other sheriff, they may farm it out to another sheriff to go serve it, but it's one clearinghouse. And the statute says, shall issue the writ of execution, okay? And so yes, it's through one clearinghouse, if you will, or one official, however you'd like to approach that. That is exactly our position. We only had one writ of execution. Now, we garnished many assets. And I would pose to you that if they have an exemption in any of those assets, then they have the right to come in and argue their exemptions. In this case, they filed a motion to quash. Unfortunately for us, we believe the district court wrongfully quashed it. May I summarize, or am I? Okay.
Oh, you may sum up.
Thank you. In summary, we ask that you find the district court erred as a matter of law and incorrectly interpreted the statute. And we would ask that you remand to the district court, specifically allowing for the garnishment approach that we took. Otherwise, it's going to be a very long and tedious process. And we just don't, based on the reading of the statute, the cases, the Home Pride case, we don't believe that that's what the law is. Thank you.
Thank you as well, Mr. Arling. Mr. Kane, are you going to respond?
I'd like to talk about 2 things. In the record, appendix pages 350 to 355, DuTrac said, quote, as DuTrac is the primary unsecured creditor representing over 80% of the unsecured debt, the interest in the closely held entities and any cash payment for those interests has a primary and virtually sole effect on DuTrac. And then later, their counsel, Mr. Arling, said during the hearing, as to whether, and I know there's some discussion, I believe Mr. Kane commented, we don't want to drag Westgate into the state court for a fight that really is Doug and Sheila's Hefel bankruptcy. The beauty there, Your Honor, is because the fight is related to the estate, this stays in the bankruptcy court. It's also interesting to note that DuTrac, during the bankruptcy proceedings, tried to actually buy Mr. Hefel's shares for $250,000 and then withdrew that, apparently after reviewing the operating agreement for Westgate. In light of these considerations, we don't think it's appropriate for DuTrac to say that they really were sort of innocent bystanders in the bankruptcy proceedings. They were active, they were voluntary, they presented vigorously in connection with it, and I believe under the Gaylord case that the Grinnell case that I've cited before, they participated, they got their money, Westgate gave up a valuable right to collect money, and in the end, this court, the Iowa District Court, Judge Bitters should have given effect to Judge Kilberg's order, which he did not. I mean, I think it sends the wrong message that we're not going to abide by orders in the bankruptcy. The fact is, the bankruptcy was not dismissed. It was not expunged from the record. It's still there.
But this
It's
still
just
gets
the
back,
revocation.
this still kind of begs the question of what's the effect of that order. And as I read the order, it's deciding that certain assets are going to go into the bankruptcy estate and certain assets are going to go to Mr. Hefel personally. And then there's subsequently a revocation of discharge, which sort of expands the field of assets that DuTrac can go after from the bankruptcy estate to also Mr. Heffel's personal assets that were excluded from the bankruptcy.
With
And
respect,
what's wrong with that?
With respect, I only believe that the effect of the excuse me, effect of the revocation is to any other creditors in the bankruptcy. It's not as to DuTrac, because DuTrac was involved heavily in the compromise and ultimately gave up its position,
Well,
its
yeah,
appeal,
again,
and took the money.
I hate-
I don't think they can't have it both ways.
Well, I hate to be argumentative, but, you know, all the information based upon leading up to Judge Kilborg's order, you know, subsequently, you know, I can't imagine that Judge Kilborg would have entered into that compromise agreement if all the true facts were there and present. So to give what I'm considering to be preclusive effect to Judge Kilborg's order based upon what has subsequently been determined to be fraudulent information, you know, I have a hard time wrapping my head around that's needs to be given preclusive effect then, which is really what you're arguing, is that they participated. Of course they participated. They had the largest stake of any of this bankruptcy thing. They wanted to maximize any recovery that they could. Of course they did. And then to fault them now for saying, oh, well, then they withdrew their appeal. Well, if we didn't have fraud after the fact, they would have gone away and had no options available anyway.
But I think the record is clear that there were options. They pursued one. They tried to buy the shares for $250,000 and they didn't.
Well,
They-
but of course
they
they had
had-
options within the context of the bankruptcy. They have options, and that's their job, is to try to maximize whatever they can out of that. Unfortunately, it didn't work because the bankruptcy court didn't go along with it based upon inaccurate information. So to
But
come
none
back
of the
now-
inaccurate information involves Westgate. Westgate was fully disclosed. Westgate was known. They had all the financials, they had all the record shows, they had all the operating agreement, all of the information that they needed to evaluate what they wanted to do with that. So I'm here on behalf of Westgate saying, not on behalf of Douglas Sheila, but on behalf of Westgate saying, DuTrac had all the information about Westgate. There's nothing fraudulent about Westgate. The entire bankruptcy proceeding was not expunged, removed, wiped clean. It's only the very last step as to the discharge to Doug and Sheila Hefel. But as to Westgate and as to DuTrac, there was consideration, there was participation, there was discussion, there's a court order that has not been set aside that your predecessors have said we should give effect to. So I'm trying to say here today, we should give deference to the precedent and keep the compromise binding and allow the efficacy of Judge Kilberg's order to prevail. All of that has nothing to do with the claims that happened later about finding a boat or whatever else there was, which I won't go into now. So for those reasons, we're asking that you give Judge Kilberg's order effect, that they be held to it, they being DuTrac, and that the charging order be overturned. Thank you very much.
Thank you as well, Mr. Kane. The case of DuTrac versus the Hefels and Westgate is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.